This very well might be the first international symposium on protecting user rights from contractual override. It might be the only symposium ever about this subject. First, between the double negatives that we're trying to protect ourselves from contract clauses, this is already kind of complicated, but it's also complicated because there's a lot of overlap between this topic and related topics. So just to make it very clear, what we're talking about, we'll first talk about what we're not talking about. We're not talking about those clauses in law protecting authors from publishers. We're not talking about that here. We're talking about sort of a related issue, which is basically protecting user rights from publishers. Second of all, we're not talking about the various state legislation that is protecting libraries against excessive pricing. Very important, but that's not really what we're talking about here. And also, we're not really talking about digital for sale or controlled digital lending. Again, there's overlap, but that is not the core subject of what we're talking about here. So what are we talking about? This kind of awkward phrase, contract override prevention clauses. More and more content is being distributed digitally, and almost all of it is being distributed subject to licenses. Okay, so this really started in the 70s and 80s with software, and now it's pervasive with all the other kind of content that we access. And those licenses often have terms that limit copyright exceptions. Since 1991, various directives in the EU relating to copyright have contained clauses that specifically require the nullification of license terms that override specific exceptions mandated by the directives. The basic principle is, what was the point of negotiating and adopting these exceptions if the licensor could simply override it with a license term? That's the very simple principle. And that's what the folks starting in the Commission recognized back in the 1990s and have carried forward. So far in 4 directives, we have these clauses. The software directive contains exceptions for the making of backup copies and copies that are made during the course of reverse engineering. And the directive says that any contract term that tries to prevent those activities is not enforceable. It's null and void. Similarly, the database directive has exceptions for making copies that are necessary for the use of the database and for copying insubstantial parts. And there too, it says any contract term that is contrary to those exceptions is not enforceable. Marrakesh Directive, the clause says any contract term that tries to limit the making and distribution of accessible format copies is not enforceable. And then finally, just a couple of years ago, in the Copyright in the Digital Single Market Directive, there are exceptions for text and data mining, for online education and for preservation by cultural heritage institutions, and those too cannot be overridden. Because those are directives, they have been implemented by all EU member states. And so all the member states have at least those very targeted clauses. Now, in addition to the EU member states, you have all these countries that are seeking EU membership. They have all adopted at least the software directive limitations, because that's the oldest in time, and they've had a chance to do it. They presumably will start adopting all the other ones, certainly by the time they join the EU. We're starting with 27, but the number keeps on getting bigger and bigger, and it gets even bigger because you have the European Free Trade Agreement members. Those countries have similar provisions. And then we have other countries around the world that have adopted similar kinds of targeted exceptions. So Australia, Greenland, Malawi, New Zealand, and then Russia. But then there are 13 other countries that have gone way beyond what the EU has done. And they have contract override prevention clauses that are far more general. Some have it apply to all exceptions. So any exception that's in the Copyright Act cannot be overridden by contract. A clear example of that is Nigeria, which just signed into law this year by the president. You then see other countries that are sort of EU members or former EU members. So you have Belgium, Germany, Portugal, and then you have other countries that are, again, sort of looking to join the EU, Montenegro, Moldova. And then Singapore, the law there is much more complicated and it treats different kinds of exceptions differently, but it does show that there isn't just one way to do this. You can have sort of a more nuanced approach. So again, you have countries with these very targeted override clauses, and then you have some countries that have these much broader override clauses. So what does that look like on a map? The first thing that will leap out at you is that other than Greenland, we don't have any of those clauses here in the Western Hemisphere. Okay, this is very much an Eastern Hemisphere approach, and then even more so, you'll see that it's really a European approach. So what is it about Europe that has led it to not only sort of have the targeted approach, but even the broader approaches, as we see in the UK, Germany, Belgium, and Portugal? And then how do we see if we can get some of those protections elsewhere, especially here in the Western Hemisphere?